what are the next point of discussion we can say, what are the remedies in case of breach of contract? See, these are the remedies in case of breach of contract. The first one is rescission of the contract. The second one is suit for damages. The third one is suit for contumacy. Then suit for specific performance of the contract, suit for injunction. And these are the 5 options available, or 2 or more options available. See, first one is rescission of the contract, that means cancellation of the contract, or suit for damages, or suit for contumacy, or suit for specific performance, and last one is suit for injunction. So let us see one by one. First one is rescission of the contract or cancellation of the contract. See, in this case, he would not be required to perform his promise. That means he is the aggrieved party is cancelling the contract. So that amounts to cancellation of the contract and termination of the contractual obligations between the parties. So this is one remedy. The first option. See, the aggrieved party can exercise to one or more remedies. Maybe he can cancel the contract and claim damages. Cancel the contract also. See, that might be one remedy for breach of contract. The second one is suit for damages. So in case any any of this party promisor or promisee is incurring some losses, see, in that case the injured party is in a position to file a case against the other party for claiming damages. And these damages may be several types of damages, special damages, normal damages, etc. that we will see later. The third option is suit for contumacy. Contumacy means, the term contumacy means as much as earned. See, in this case, whatever out of this contract or this particular agreement, maybe any one of the promisor or promisee maybe he received some benefits out of this contract. So that benefit should be reinstated, or that benefit should be restored with the help of contumacy. Contumacy means as much as earned. See, in this case, that will be that the aggrieved party is in a position to file a case against the other party like contumacy. See, in that case, the other party is required to reinstate or restore whatever benefit he received out of this contract. The another option we can say suit for specific performance. In some cases, see, the damages or contumacy, it is not, or cancellation of the contract, it shall not be treated as an adequate remedy. The remedy is to perform the contract itself. So in that case, the aggrieved party is in a position to file a case against the other party claiming specific performance. So in that case, that the other party is required to perform the contract because there is no other option, and because maybe sometimes the claiming damages or cancellation of the contract, etc., monetary benefits, etc., that shall not be treated as an adequate remedy for the aggrieved parties. In that case, the court can the aggrieved party is in a position to file a case against other party claiming specific performance. So see, that particular contract is it should be performed as such. See, these are the next one is suit for injunction. See, injunction means injunction is the specific performance of the negative terms of the contract. So in case of any objections to the aggrieved party, see, other party is in a position to file a case against other party like claiming injunction. So the court will in that case the court will give a temporary judgment like to keep the status quo or keep the whatever activities are going on. It should they used to ask the other party to stop whatever activities are going on there and to keep the status quo. So that order will be called as order for injunction, or the other party is in a position to file a case against the other party claiming injunction. So in case of injunction, the entire activities, whatever things are going on, it should be temporarily stopped, and the other party is required to keep the status quo. See, these are the remedies in case of breach of contract. The first one is rescission of the contract. The second one is claiming for damages. The next one is, we can say, suit for injunction, quantum merit, etc. The next topic is, what are the kinds of damages? See, damages might be general damages or normal damages, special damages, liquidated damages, vindictive or exemplary damages. See, these are or nominal damages. These are the various kinds of damages. The first one is general damage or normal damage. The second one is special damages. The third one is liquidated damages. The fourth one is vindictive or exemplary damage. And the last one, we can say, nominal damage. So we will discuss one by one what is general damage or what is special damages, in which circumstances aggrieved party can claim special damages, or what is liquidated damages, what is exemplary damage or vindictive, and what is nominal damage. The first one is general or normal damage. See, in case of general or normal damage, the aggrieved party is in a position to claim only the actual loss, whatever actual loss incurred, that can be claimed from the other party. The amount of general or ordinary damage is restricted to only that loss which arises naturally and in the normal or usual course of things of such breach. So this is in case of general or normal damage, the aggrieved party is in a position to claim only normal damage, or what is the normal damage restricted, the damage due to natural and in the usual course of things of breach of contract. The second one is special damages. See, in special damages means in addition to the general or normal damages, the aggrieved party is in a position to claim some additional damages due to certain special circumstances, and the parties know. See, in that such kind of damages will be called as special damages. See, we will see some of the case studies, like in order to discuss some terms like special damages. There are certain case studies. First one is Hadley versus Baxendale. See, in this case, one mill owner, one mill stopped due to the breakdown of shaft, and the mill owner, he delivered that shaft to a courier company for repairing, and X did not mention the courier that in case of any delay in delivering this shaft, it will cause some losses, and due to the delay in delivering the shaft, the mill owner, he faced some losses, and that mill owner filed a case against the courier company, claiming that loss due to the non-operation of the mill. See, in this case, the mill owner, he is not in a position to claim the special damages, because he did not inform the courier company that in case of any delay in delivering the shaft, it will cause some additional losses. So in that case, the mill owner, he is not in a position to claim any kind of additional or special damages. And there is another case study called as Simpson versus London Northwest Railway Company. This is also related to special damages. See, in this case, what happened? Simpson, he sent some goods for exhibition in an agricultural show. He clearly informed the railway company that in case of any delay in delivering these commodities or goods on a particular date, it will create some losses, because we are sending this consignment only for getting some benefit in order to exhibit these goods in an exhibition. He clearly mentioned that must be at Newcastle Monday, certain. So that means that commodity should be there. We are assuming that the commodity should be there on Monday on a particular exhibition date. But due to the negligence of this railway, that commodity did not reach there at appropriate time. That means on Monday, and Simpson faced some losses. He is not in a position to exhibit the commodities in exhibition. So in this case, railway company is required to pay loss of profit because of Simpson is not in a position to participate in the exhibition. And similarly, one more case study is there, Madras Railway Company versus Govinda Rao. So this is also related to special damages. See, Govinda Rao, a tailor, he delivered some sewing machines and some cloth to a railway company to be delivered at a place where festival was to be held, and he expected to earn some exceptional profit by participating that festival. But what happened due to the negligence of these railway authorities, that sewing machine and cloth did not reach there at the appropriate time, and he lose the opportunity to participate in the event. And in this case also, Govinda Rao is in a position to claim special damages, because it is he clearly mentioned that this commodity should be there at the right time. And so these are the case studies related to the special damages. The next one is liquidated damages. So what is liquidated damages? Section 74 defines what is liquidated damages. When a contract has been broken, if a sum is named in the contract. See, this is actually a penalty. This is actually a penalty in order to ensure that a particular contract is or a particular agreement is executing at the right time. See, in order to ensure that maybe in a specific contract we are fixing certain penalty. For example, in case of a construction contract, we used to in order to ensure that the contract is executing at the right time, we used to enclose at the agreement itself, we used to say, in case of the contract is not executing or testing, commissioning, handing over is not within a particular period of time, you are required to pay damages. That damages might be an abnormal figure, like in each and every day, like 1 million dirhams per day, etc. So this is actually a penalty. This is just for ensuring that the agreement or that particular contract is executing at the right time. See, in order to ensure that particular contract is executing the right time, we used to say some kind of penalty will be imposed if you are not executing the contract at the right time. Such type of damages will be called as liquidated damages. This is actually a penalty or a punitive damage only. The next one is vindictive or exemplary damage. See, this is also just like the previous one, just like what we can say, the liquidated damages, but there are certain differences. The damages for breach of contract are granted to compensate for the loss suffered by the plaintiff, and not with a punitive nature, or not to penalize the wrong done by the defendant. See, this is also just like vindictive or exemplary damage is also just like the liquidated damages, but this is the whatever normal loss incurred by the plaintiff, he is in a position to claim, and this is not a punitive one. This is not to punish any of the contracting parties or defendant in this contract. So hence the damages granted are not vindictive or exemplary or punitive in this case. So these are the next one is nominal damages. See, this is also a type of damage. See, in this case, for the name's sake, in order to show that one party suffered a lot, and in order to show that see, this is a pure breach of contract, sometimes the court used to say rupees 1 rupee fine, something like that. So such type of damage will be called as normal damage. This is only where the aggrieved party does not suffer any monetary loss. Sometimes the court grant a normal amount like cost or maybe rupees 1, etc. See, such type of damage will be called as nominal damage. This is just to show that see, some kind of breach of contract occurred. See, these are the discussion about our Indian contract at 1872. So with this our discussions about various discussions about, we discussed everything about the Indian contract at 1872 regarding how to make a contract, what is promise, what is contract, what is agreement, what are the essentials of contract, see how to perform a contract, and what are the remedies in case of breach of contract. Okay, welcome back to business law counseling classes. So this session we will discuss about another important enactment called as company law, the Companies Act 1956. See, Indian company law is closely related to, or closely following, or greatly influenced by English law, English Companies Act. Even the language of many of the statutory provisions, not only Companies Act, many of the enactments are identical or corresponding to the provisions of English rule. The first Indian company law was enacted in 1850, and the concept of limited liability was recognized for the first time in India in 1850, the Companies Act 1857. The Companies Act 1866, which repealed all the entire statutes, remained in force till 1882. And the Companies Act 1882 was repealed by the Companies Act 1930, which mainly based on the English Companies Act 1908. A drastic amendment of the Companies Act 1930 was introduced in 1936, which came into force in the statute book. It will be called as the Companies Act 1956, which will be the more similar to, or mainly based on, the British Companies Act 1948. See, this is so right now in India, the Companies Act 1956 is in force. See, section 3 subsection 1, suppose we are talking about the definition of company, section 3 subsection 1 of the Companies Act 1956 defines company. So according to section 3 subsection 1, a company means a company formed and registered under this act, or an existing company which is a company registered under any of the earlier Companies Act. So this is the definition of company as per the provisions of the Companies Act 1956. So according to section 3 subsection 1, company means a company formed and registered under this enactment, or an existing company which is registered under any of the previous enactments. Then suppose we are talking about a company, generally we can say company is an association of two or more persons forming to associate together, or forming together, contributing to a common stock called as share capital for doing some business profitably. So the common stocks are contributed is denoted as share capital of, or the capital of the company. The person who is contributing to the common pool or the share capital of the company will be called as shareholders or members. The proportion of the proportion of capital to which each member is contributing called as his share, and the share in a company is transferable. This is the most important feature of joint stock companies, that shares are freely transferable. So let us see the features or characteristics of joint stock company, the most important characteristic of joint stock company is that it is an incorporated or a incorporated registered association. Company, as per the provisions of the Companies Act, the registration is compulsory. See, without incorporation or without registration, we cannot constitute a joint stock company. So the minimum number of members in order to incorporate or register a joint stock company is that 2 in case of private limited company and 7 in case of public limited company. So the company is a joint stock company or a corporation. Company is an association of 2 or more persons in case of a private limited company, and 7 or more persons in case of a public limited company. It is an incorporated or registered association. The second one is artificial personality or artificial person. A company will be treated as an artificial person. So company is having an artificial personality apart from its members. Members are having, the shareholders are having a natural personality, but a company in front of the law, company will be treated as a person. A company is having all the rights, just like a person, a citizen. Company is having all rights like to possess the property, purchase the property, sell the property, and be sued and be sued. See, the third important feature we can say, it is having a separate legal entity. The company is a different entity, separate entity apart from its members. Members is having a separate entity and company is different. Company is incorporated. Company came into existence by registration, or it came into existence by operation of law. Similarly, company come to an end by operation of law only, because company is having a separate personality, separate entity apart from its members. And next one is limited liability. This is one of the important feature of joint stock companies and limited liability. If we consider any other forms of organization like sole trader or partnership firm, in sole trader and partnership firm, the liability of the members are unlimited. But in case of joint stock company, the liability of the members is limited. It is limited by either by shares or limited by guarantee. Limited by shares means the liability of the members is limited to the unpaid value of the shares only. And in case of companies limited by guarantee, the liability of the members is limited to the guaranteed amount. At the time of incorporation, each and every member is required to guarantee the liability. So the members' liability is limited to the guaranteed amount only. The next feature is, we can say, separate entity, a separate property. Company is having the legal right to purchase, possess, similarly dispose the property. The company's property is different and the shareholders or members' property is different. And the next one is transferability of shares. The shares, the shares of joint stock companies or companies are freely transferable, especially we can say public limited companies. The liability, the transferability of shares of private limited companies is restricted, but in case of public limited company, it is freely transferable. It can be, see, the shares of joint stock company can be transferable, or purchase and sale is possible through stock exchanges. And the next one is perpetual existence. Company is having then perpetual existence, a separate existence and permanent existence apart from its members. The members may come and go, but the company will be the same. The company is having the composition or the name or company will be the same. The members will come and go because the shares are freely transferable. The ownership, the owners of the company will come and go, but the company will be the same. Even in a joint stock company, the entire members of a joint stock company is no more. That means suppose in an annual general body meeting, usually annual general body meeting we used to conduct in some stadiums or some halls, some places only. So in a particular annual general body meeting, even a bomb exploded and the entire members are dead, and no live members are no members are alive right now. Even then, the company will be there, because company is having a perpetual existence in front of the law, because company came into existence by incorporation, and the company came, see, the operation, it can be, see, wind up only through operation of law only. So that will be called as perpetual existence, because the composition of members, it will never affect the existence of an organization. The next one is common seal. Company is having only an artificial personality, and only the directors or the shareholders, they used to do all the day-to-day affairs or the management of the company. So in order to reflect that the company is doing the activities, there should be a common seal, and that should be fixed in every or the transactions whatever the company is doing. Then last point is company may be sued and be sued in his own name. So these are the features of joint stock company. The first feature we can say a company is having company is an incorporated association. It came into existence by registration or by incorporation. See, the next one is company is an artificial person. The next one we can say separate legal entity, limited liability, separate property, transferability of shares, perpetual existence, common seal, and company may be sued be sued in his own name. See, these are the features of a joint stock company. The next question is a company a citizen. See, company will be treated as a corporate citizen. A company, though a legal person, even though will be treated as a legal person, company shall not be treated as a natural person, and cannot be a citizen under the Constitution of India or the Citizenship Act 1955. The company shall not be, even though company is a legal person or a legal personality, a company cannot be treated as a citizen under the Constitution of India or the Citizenship Act 1955. A company has no fundamental rights which are expressly available to citizens only, but at the same time company is having all the right to purchase property, possess property, see, they can use the property. However, it can claim the protection of these fundamental rights which are applicable to everybody irrespective of them being citizen or not. See, that means company is having all the right to purchase property, possess property, and dispose property, etc. But company shall not be treated as a citizen as per the Constitution of India or as per the Citizenship Act 1955. But they can enjoy all the benefits or fundamental rights of as a citizen. Okay. See, the next point is lifting of corporate will. See, company is having an incorporated association. Company is having some protection in front of the law, but at the same time the corporate will, sometimes the company law board or the concerned authorities, including the registrar of companies, etc., they used to lift this corporate will, and they look into the matters or what are the people who are involved in this company. In case of a dishonest or fraudulent use